The Uniform Commercial Code, or UCC, governs contracts for the sale of goods. For UCC purposes, goods are tangible things that are movable at the time they are identified for sale, or in other words, become the subject of the contract. But does computer software, which is the fruit of intangible intellectual labor, fit within the definition of goods? In the 1991 case of Advent Systems versus Unisys Corporation, the Third Circuit had to decide. In the 1980s, Advent Systems, a British company, agreed to provide electronic document management software to Unisys Corporation for resale in the United States. It also agreed to provide certain support services. The agreement was supposed to continue for at least 2 years, but it wasn't long before Unisys restructured and decided that it would actually be better off developing its own document management software. To that end, Unisys informed Advent that the agreement was over. Advent sued Unisys for breach of contract, among other claims, in federal district court. An essential question in this diversity case, controlled by Pennsylvania law, was whether the UCC and its statute of frauds applied. Under the UCC's statute of frauds provision, contracts for the sale of goods worth $500 or more are generally unenforceable unless they meet certain writing requirements. The district court ultimately ruled that neither the UCC nor its statute of frauds applied, and the jury awarded Advent over $4.5 million in damages for breach. On appeal to the Third Circuit, Unisys maintained that its agreement with Advent was primarily one for the sale of goods, and therefore subject to the UCC and its statute of frauds.